delivered a judgment as a session judge, which went to High Court of Allahabad. He was at Lalu, High Court of Allahabad. And that judgment, his judgment was set aside by the High Court of Allahabad, where there were 5 judges, all of them were English judges. हमेशा छुपेगा कुश्तों का खून क्यों कर, जो चुप रहेगी ज़बान खंजर लहू पुकारेगा आस्तीन का. Because there is that must be in fact considered by the judges, every judge, that today if he does injustice, in fact he is also going to be judged. There is a final judgment going to come after this one, annihilation of this entire universe. So that must be there. And I tell you about this judge. He is none other than the son of founder of the that is Sir Syed Ahmad Khan, Aligarh Muslim University. He is the founder of this one. His son, and he had done Bharat law at the age of 22. Then came to India, and he was appointed at the session court or city court, session court, certain court, and he delivered a judgment as a session judge, which went to High Court of Allahabad. He was at Lalu, High Court of Allahabad, and that judgment, his judgment was set aside by the High Court of Allahabad, where there were 5 judges, all of them were English judges. Now, that judgment of High Court was challenged before the Privy Council. That time our Supreme Court was in London, that Privy Council, or Judicial Committee of Privy Council. And that Privy Council, I have read that judgment. In that case, the judges of the Privy Council, after seeing it, they restored, they set aside the High Court judgment, which set aside Justice Mahmood's judgment, and restored Justice Mahmood's judgment, and then said, why services of such an eminent judge are wasted at the district level. And immediately thereafter, they appointed him in High Court of Allahabad. Whereas he had given this important dissenting judgment, which was very appreciated. He was there hardly for a period of 12 years on this one. So you must have, in fact, the confidence, and you should fight out if any injustice is done. And this worst thing, if any injustice is done by an authority who is supposed to do nothing but justice. That is, court of law is supposed to do justice. Now, in these cases which have given and cited, there is not written what are the, in fact, the evidence of witnesses. But it seems there is no substantive evidence. Only there are men known to police, they have recorded, and the trial court don't seem to have, in fact, gone through this one or taken care to see that there is some evidence which is reliable, so that, because that was the stage where we are not acquitting a person, but we are only granting him bail if there is no solid evidence against him. So, if there is no solid evidence, you must try to go to the higher court. You are more likely to succeed in the higher court. Now here, and see, most of them, the cases simply of conspiracy. And they have collected from their witnesses. They say there are some police-bound witnesses are there. These are recorded statement of their own, and they are presented to the court. This one, but ultimately they can never, in fact, sustain. Such evidence will never sustain at the trial stage when the other side, this one, cross onions. And our colleague, Mr. Bhushan, he also told you about certain things and very boldly told about the situation which is going on in the court. And he said that, that you must fight it out, and then you must have confidence, and you are having confidence, you must fight out. And because there are so many cases where people was ultimately found innocent, and he was in jail for more than the period for which he could have, in fact, a sentence in that on the conviction. That was the thing. and ultimately found to be very innocent. There was no evidence at all, no substantive evidence, and therefore reliable evidence, and therefore had to be this one. So here, all these cases which we have heard, we find that there is a good, they have got very good, bright chances. But you have not given us the contents of the police statement by other witnesses. In one case, several witnesses have been examined. We have given the gist of that. But then it appears, because normally the trial court, when the application is made for bail, he must try to scan the evidence prima facie, on the face of it, whether it is reliable. That time we can't decide whether it is reliable or not. But prima facie reliable or not. And that is very easy to find out whether a person, whatever he says, this is the only moral evidence, whether it is prima facie acceptable, reliable or not, or can be rejected. In that case, the person, it is in fact cruelty to keep a person behind in the jail for a number of years without there being any reliable evidence. So therefore, these all cases seem to be, in my opinion, in the views of my colleagues also, that they must go in appeal to the higher court and fight out. It depends on the person who represents you and goes to the, in fact, length and breadth of the matter and try to find, to show to the court that absolutely there is no reliable evidence for which his conviction can be laid down. Thank you so much, but yes, I appreciate, as I said, in fact, this, the persons, the committee who has arranged this one, so that it will give courage to the innocent person to fight out these cases in the courts of law where injustice is done. Because this must be peaceful. And of course, if you try it, a will will find a way. A will find a way out. And surely, and I also advise you to go, in fact, telling it in the higher courts. Thank you.